I'm here, Your Honor.
Good morning, Ms. Booth. Thank you for being here.
Of course.
And Ms. Day, I know you were on this matter, and then you did file your report, and I think there was the request to not participate in future proceedings after your recommendations were filed. Are you still participating today, or?
Yes, I still have to participate until a final order is entered. I'm just not doing any ongoing investigation unless the court needs additional information from the original court visitor appointment.
Okay, great. So it looks to me, one of the reasons we set this over last time, essentially we had everything in place, but for a DCYF response. So we did resend that order, and we got the sealed records back on November 13th. So the court does have those now, and I have reviewed them. And there's no disqualifying factors in that CPS, in those CPS documents, excuse me, getting tongue-tied. So Ms. Day, I guess I'll turn it over to you if you have any further input from the court beyond your recommendations.
Just that, Your Honor, it is time to enter the final order and allow this matter to be completed. There are no parents available or capable, and this child needs to have a permanent solution. And Ms. Booth has, come forward and been that person. She's been involved with this child for a long time. The child is doing well overall, and this is the appropriate time to sign those final orders. I believe those have all been provided.
Yes. So Ms. Booth.
Yes.
Gonna do, I think that we are ready to finally get this done for you.
Yay.
This should be an exciting day for you. Thank you for being so diligent with all of this and patient through the process. I know it's been some time coming. What I'm just gonna do as I go through your proposed order is just I'm just gonna swear you in so that the statements you make to me as I go through this order are under oath. So go ahead and raise your right hand. For several months now.
Yes.
You can put your hand down. And then I was just, the very first ruling I have to make is whether this is a full guardianship or a limited. Full means there's no visitation by the parents at all. Limited, there is some visitation allowed. I did see in your proposed order that you are allowing visitation with Alicia Dyer when the minor child wants to see her.
Yes.
Is that correct?
Yes.
And the same for now, Mr. Bishop. You had included his name on here. Hold on. You had included his name, but did not put any statement of visitation. Were you intending there to be any visitation with Mr. Bishop?
I was not.
Okay, I'm just going to go ahead and take that out.
Okay.
So I'm going to grant this as limited only because there is visitation allowed for by mother. That's the only thing that limited means. You're going to have you're going to have full decision making, educational, healthcare, etc.
Okay.
So this will be a grant of the full minor guardianship. We did get the report. We have no reason to believe that the child has any Indian or Native descent, correct?
Correct.
Not the member of any tribe.
Correct.
There's no dependency case open for the child.
Not that I know of.
Okay. And then Washington courts have jurisdiction over the minor child because this is the child's home state.
Correct.
And the child has resided here, I believe, all of their life. Is that correct?
Yes.
Okay. I'm not putting any limits on your authority regarding the upbringing and decision-making for ASRE. I am finding that we're limiting visitation because of allegations of abandonment and neglect by the parents. And that is why we are limiting visitation essentially to the minor's wishes and your wishes.
Okay.
You're not requesting any support, insurance, or taxes.
No.
Does the minor child, is there any sort of child support order in effect, or does the child receive any sort of state assistance?
I have food stamps with her on it, but other than that, no.
Okay.
She's on state health insurance through her mom's name, but I already called the health insurance people, and they said once I filed the guardianship paperwork through them that they would transfer it to my name. So
Okay, I think what I'm just going to include on here, Ms. Day, let me know if you have a better idea for this, but my thought under other findings was to indicate that none of this would preclude the state of Washington from bringing any sort of action for child support if it deemed necessary once they receive this order.
Yes, I think that's appropriate. And I also think it's appropriate for Ms. Booth to have the ability, if she files taxes, to claim the child, as she's had the child this entire year and will continue to, subject to whatever other, state and federal income tax laws and things like that.
mhm.
Absolutely agree with that. Let me go to 22. I'm going to change your wording a little bit.
Okay.
And what I'm going to say is for tax issues that you as the appointed guardian may claim the child.
Okay.
And then I'm going to indicate any sort of child support or health insurance reserved for state of Washington if they were to determine that was necessary to bring an action against the parents for support payments.
Okay.
Okay.
And Your Honor, I'll need to make sure that my court visitor fees are included in that final order in order for payment to be processed. It's not processed until that order is finalized.
Gotcha. Okay. I will get to that too. Thank you. No protection order is requested. Is that correct?
Yes.
Okay. You will have school healthcare decision-making authority to apply for passports and travel, driver's license if and when needed. You'll have access to all school and educational and healthcare records. Are there any other specific records that you're knowing that you would need to have included in this order?
I do not have her birth certificate.
Okay.
And her current guardian is holding it hostage until I'm awarded guardianship. So
Okay, I'll put in birth certificate here.
okay, thank you.
We might want to put in social security card too.
Okay.
Okay. I've left visitation with Alicia Dyer as essentially at guardian and minor's wishes.
Okay.
Now change the support, insurance, and tax issues as we just described.
Okay.
The GL is discharged from this case. The total fees and costs are approved. And I did see the request in here, so I can input. Is it just the amount in the November 2 motion and order, or has that increased at all?
No, I'm not gonna amend it to increase it for the couple of hearings that we've had. They've been short, so that's fine.
Okay. So I think what I have is the 500. Does that look right to you?
Yes, Your Honor.
Okay. So I will put that in there. We didn't have any lawyers involved in this case. Successor guardian, I don't know if I have enough information.
It's my mom.
Just let me go back. I don't know if that was part of the GAL report.
It was not, Your Honor. I was only appointed as the court visitor, but I was aware that in the event there was any concerns for Jessa or her health decompensated, that there would be somebody to care for Asri.
Okay. My only concern with including the successor is that I don't have any of under a guardianship statute, I don't have any of the criteria, bankruptcy, criminal history, CPS reports, that sort of thing to
I understand.
say whether she would qualify. So I am going to take that out for now.
Okay.
What I will write is certainly there is a method by which you can apply to have a successor guardian added. And I'll just indicate reserved for future motion.
Okay.
Bring that, and then essentially you would be providing criminal, like a watch report like you did with your own petition and that sort of thing. So the court can make a ruling on whether that person would qualify as a successor guardian. Okay.
I understand.
Okay. Anything else from Ms. Booth or Ms. Day? Otherwise, this is an order to sign.
Do I need to file anything other than like an acceptance or like?
Nope, this is it.
Okay.
The clerk will prepare the final letters for you to pick up, and that will be in a couple of days.
Okay.
Great. All right, thank you both. Ms. Booth, congratulations, and thank you for what you are doing for this minor child.
Thank you so much.
Thank you.
Welcome. Good morning, Mr. Esau. How are you?
Good morning, Your Honor. I'm well, and you are well too, I hope.
Indeed. Post-holiday, getting back into the swing of things.
Right. I'm here on behalf of Christina Betters, who is the mother, and she is also present by Zoom.
Okay, great. And I know when we were here last on November 7th, I did extend the emergency minor guardianship through today's date. We did appoint Mr. Esau to Ms. Betters. We did also appoint a court visitor. I know November 7th to November 28th is not a whole ton of time really to dive in and get a lot done. But maybe first I'll ask you, Mr. Esau, how your client wants to proceed today.
Your Honor, my client filed a declaration and an objection to the emergency guardianship petition. There's also been a declaration filed by Brianna Billick, who is the aunt on the father's side. We don't have a DNA test yet for the father, but everybody has been treating him like the father, and obviously my client knows he's the father. So I think what my client wishes to do is basically the emergency petition spells out a situation where these are not the things that the child is used to. There's been an openness and a working togetherness between all the parties, including the alleged father and Christina and Miss Rowland. The precipitating event here was some sort of monster mash party at the local school because Marley didn't want to come home with Pamela and wanted to come home with her folks. And that has been a very open situation. So I'm considering the declarations that I've read so far. This is quite unusual, I would think, for most of our minor guardianship cases. The parents have been in a situation of homelessness, but they now have stable housing under Section 8 down here in Vancouver. The mother has a job now, so she's working. They've both been supportive of, by providing food, clothing, help with school funds, sports activities, all that kind of thing. We're not talking about a drug and alcohol situation here. We're not talking about a domestic violence situation. Not sure that there's really any allegations other than in the emergency petition that apparently my client isn't able to manage intense emotional situations with Marley without any evidence alleged that there's a basis for that. So we probably need a hearing, but I think what my client is suggesting in her paperwork is that let's go back to the way things were. Let the parents have equal decision making with Pamela. Remove the restraining order. Remove this business of not being able to visit with the alleged father, and that visitation somehow needs to be supervised, because it doesn't. They've all had equal openness and visitation throughout this whole time when they've been separated from their daughter, and they voluntarily placed their daughter with Ms. Rowland. There's an allegation that my client's housing is unsafe, but this is Section 8 housing, so I'm not sure how that. I mean, I haven't seen the housing, but we can certainly have Ms. Day take a look at that. But if she's willing, of course. And, so this is an unusual situation. So I could see where the court's options are to either make this a limited emergency guardian until we can get more information from Ms. Day. And, perhaps I don't know if she's had a chance to talk to my client yet. So I'll let her talk about that. But really, it should be a very limited guardianship with equal access to the child by both parents and by Ms. Rowland, and they continue to make collaborative decision-making, which has been in the best interests of Marley and has been successful for the last 7 years, because that's the amount of time when she was 2 when she was placed, and they were homeless at that time, and they didn't want the child to be couch surfing. So it seems to me there could be a very limited guardian, emergency guardian at this point. I don't know if we have a petition yet for a permanent guardianship situation, but we certainly don't have the normal factors in this case that we've seen in other cases in the past. So I think it's in the best interest of the child that we all acknowledge that the parents are equally involved and have equal decision making with the proposed limited guardian. So yeah, we don't need a restraining order for sure, and none of the other restrictions to visitation like the petition alleges. So thank you.
Okay. And I will go to Ms. Day next, and then Ms. Rowland, I will come to you. I'll just note the ex parte order that was signed did have a restraint provision. When I reissued after the first appearance, I declined any temporary restraints. So I think I checked the box, no request made. It should have said request denied, because I guess the request was made. I just chose not to include it. I did include, though, that visitation would occur at Ms. Rowland's home between mother and child with Ms. Rowland present. And it sounds like your client's requesting that that visitation goes back to something more informal, unsupervised. Is that right?
Yes, that's been the pattern for this child. I've heard in family law cases that the judges try to make things as consistent as possible for the child while parents are getting divorced. This is an unusual situation where we don't have much evidence of abuse or neglect. We have some pretty responsible parenting going on here. And I do see that on your November 7th order that no request was made and it should have been request denied. I got a little confused because there was a temporary order that was not requested, but then there was a restraining order requested. So
yeah,
thank you for pointing that out.
Yeah, and I'll make sure in whatever we do next that unless I hear something different from Ms. Day, I don't see a basis for a restraining order with mother. Obviously, father isn't yet a party to this because of the paternity, so I don't really have jurisdiction over him. But Ms. Day, let me turn it over to you for any input. And again, I fully acknowledge you were appointed November 7th. It's only November 28th, so I'm not expecting the world here.
I appreciate that, Your Honor. Especially in this situation, because I've not had contact with either the petitioner or the parent. So I am hopeful that now that we've been in court, they will be able to reach out to me. I have sent mail to them. The letter to mother came back, so I have prepared another one. I think I misaddressed that based on the pulling the address out of Odyssey, and I haven't heard from Miss Rowland. I'm more than happy to go do a home visit if there's any concerns about the petitioner's home. But from what I have read and reviewed in the file, I would have to, at least to some degree, agree with Mr. Esau that visitation should be as it was, and that there's no reason for no allegations made in anything I've read that would indicate there's a harm or a risk of harm for the child to be visiting with mother.
Okay. So Ms. Rowland, if you're able to unmute, thank you for being here today.
I just have a couple of things. I didn't realize I was supposed to reach out to Ms. Day. I thought she was going to reach out to me, so I don't have a problem calling her. That's not a problem.
No problem.
Other than that, Marley's parents have been here, or Christy's been here 3 times since last court date, and her father, Jesse, has been here 2 of those 2 times, so I have not denied him visitation. I never requested a restraining order on purpose. Remember, the court had whited that out for me because me doing the paperwork myself, I didn't understand half of it.
Understood.
So, and this whole thing started, and we've had a good relationship. There's always been good things. This whole thing started, you're right, at the Monster Mash. When the Aunt Brianna brought Jesse and Christy to the Monster Mash, was inside the Monster Mash talking about how she ate edibles. And then she put Marley in the car against my wishes and drove 50 miles back to her house, not to her parents' house, to her house.
Well, hold on. I think I have to be careful here. I'm not actually taking testimony. We're not at that evidentiary stage yet.
So that's where my trust issues came in.
Understood. Let me just ask you. So what I am going to do is set a new date for this after Ms. Day has some time to chat with you and child, most likely. But let me just ask you right now, do you have safety concerns if visitation does kind of go back to your pre-filing visitation where it doesn't have to always be under your watchful eye?
I don't have a problem with her going to see her parents if Brianna is not involved. She's not, I don't want her getting in a car with Brianna after I know that she took edibles and drove 50 miles back to Camas, Washington with Marley in the car. I have trust issues. I asked her not to take her. They just totally ignored what I said, put Marley in the car and left. And poor Christy standing there, her mother, on the outside of the car, she didn't even see it coming. We were both shocked.
And Brianna is child's age. Is that correct?
She's the father's sister, yes.
Okay. So, Mr. Esau, does have any concerns if in this new emergency order, which is going to be, as you kind of suggested, just here for a few weeks until we come back for an evidentiary hearing, I am inclined to loosen visitation so that minor child can be with mother, since that's the only one I have jurisdiction over, with her, as long as Aunt Brianna is not present?
That's a good question, Your Honor. I have not spoken to my client about that. So I would have to defer to a response from her if the court wishes to have that information.
And Ms. Betters, are you able to unmute?
Yes.
So just for the time being, until we get a little more information here, are you okay with the order that reflects unsupervised visits between you and your daughter, so long as Brianna is not present?
So I mean, yes, only because I feel like I don't get to say my side of what my mom is alleging.
Understood. And we will hear from your side. Your attorney has filed, or you have filed declarations, I think, before you even had an attorney, and your
Yes, I did.
We'll have an evidentiary hearing where either you and your attorney will file your own declaration, or where you as a party will be allowed to testify to your side of the story. It's
Okay.
just now that this process has initiated, we have to do a little more investigation just about the safety and welfare of the child.
Yes.
Determine if you are a willing and able parent for the child. And it sounds like relaxing visitation to go back to what was happening pre-filing of this is in everyone's best interest. It's just that there is a concern that's been raised about Brianna. Since Brianna isn't a party, my hope is that for this short term that you'll be in agreement that we can keep Brianna out of your visitation with child for now. We'll readdress it when we decide whether to grant or deny the petition in its entirety.
Okay. And I would like to ask, because I know that it's probably going to be after Christmas, right? Would she be able to be around her for Christmas? For like family function get-togethers?
Pride.
Because Christmas is also my birthday as well, and we usually...
What day is your birthday?
December 25th.
25th. Oh, Christmas. Okay.
Yeah.
Do the parties think we could potentially either do our evidentiary hearing on December 19th, or at least have enough hearing time to discuss holiday visitation, even if we don't do the full evidentiary hearing that day?
I have another court date on December 19th to, it's called a declaration of vacating conviction. So I can't do the 19th. They're going to eliminate those past charges from like 30 years ago.
What time is that at?
That is at, let me see if I can see on here. I've got the paper. Oh, I got it written on the calendar. Hang on, that'd be easier.
I also, well, when she comes back, because I could offer Thursday, the 21st as well. I don't know if folks are going to be.
The 21st would be better, yes.
Mr. Esau, are you working on the 21st?
Yes, I am, Your Honor. As long as it's in the afternoon, I would be able to do it.
Shoot, I think it's only at 10:30.
Let me double check tonight.
Well, I have a medical appointment at 9 that morning. I don't know how long it will take.
Well, let's go back to the 19th, because also
my court is at 10 o'clock on the 19th.
Here in Cowlitz?
No, in Clark, to vacate those orders, those convictions.
You have to go in person?
No, it's Zoom, but it's at 10 a.m. in the morning, and you would be 10:30.
Well, what if we do this? Let me look at that docket, because we could be.
While you're looking, my issue with her house not being safe was the apartment complex she lives in. I mean, there's constantly something. There's shootings. I mean, and I know this stuff happens everywhere.
Right.
It's a lot there. It's
And my under a minor guardianship petition. So unlike a family law case where parents are divorcing and there's a custody and I'm determining what's in the best interest of the child, in a minor guardianship, it's a little more limited. And my role is to determine if there is a parent able and willing to care for the child. So it's a little more nuanced than just, finding the best home for the child.
No, I get it. And some of their friends are from their homeless days or sketchy at best. And that bothers me too.
Well,
I don't. That's again. I know. I get it.
I understand that. Just a second. Let me go. Well, I mean, so right now I have 7 on the 19th. So if we tentatively put you all on for 19th at 10:30, you probably would think it's 11:15 now. I can't imagine we'd call you, if we put you on kind of last case on that docket, that would take an hour to get Clark County done.
Okay, yeah, hopefully.
Or you could let them know you have an appearance in Cowlitz County. You need hopefully to be by 11.
Mm-hmm.
But it will be me on December 19th. So if you aren't here, I will know why.
Okay.
But I think this is probably a good balancing act with the holidays of the next week. Does December 19th work for Mr. Isan this day?
Yes, it works for me, Your Honor.
So I'll extend the emergency order through December 19th with the changes we've noted. Number 1, I'll make it very clear there's no restraining order. Number 2, that mother and child are allowed unsupervised visitation with each other, so long as aunt is not present for the time being.
And they would have to prearrange that, right? They can't just show up and say, okay, I'm taking her now.
Yeah, I do. Yeah, do you, Ms. Betters and Ms. Rowland, do you guys have phone communication with each other?
Yes, we get along perfectly fine. I just when it's just me and her, if other people don't get involved, when it's just me and her, we can calculate things. It's just, there's things Marley has, things that she does, not above and beyond. She's a 9-year-old girl. She has friends. And the day that that the whole thing went down bad, she had a Girl Scout event at 2:00 the next day. I told her she could go after the event, and that wasn't good enough. They took her anyway, so it's got to be structured somehow to where, they have to call and make arrangements or something.
Ms. Betters, what was visitation like before this petition? How was that being arranged?
They would call and ask.
I would ask usually on a Friday if we could have Marley for the weekend, and take her home Sunday. But that being said, it's usually on my mom's if she says it's okay or not, basically. I don't know. I mean, would every weekend, Friday evening to Sunday evening work? If she had any events or anything, we could make sure that she was able to get to those things. Yes.
Ms. Rowland, would that work for you, since it sounds like that's what you all were doing before?
Well, it wasn't every weekend. It was like every other weekend. And my issue with that is transportation and trust that she will get to these events.
So Ms. Betters, what's transportation right now?
Sorry. So Marley's other grandmother is retired, and she's got nothing but time and is willing to drive her to where she needs to be.
Okay. So I think I've reviewed this file, and I have to agree with Mr. Esau to some degree as well, that this isn't our typical guardianship case. It does seem like the argument from Ms. Rowland appears to be a little bit more family law oriented than emergency guardianship oriented, but I do want to give Ms. Day time to investigate this. So what I'm going to allow is, absent any red flags to me, is that Friday evening to Sunday evening, Ms. Betters can request that Marley be with her, and she can have visitation every weekend. Now, if there's a weekend that Ms. Betters can't have visitation, I'm not going to force visitation every weekend if you're out of town or you have something going on, but I'm going to allow it. So Ms. Rowland, If she calls you during the week and says that she is ready, willing, and able to have Marley for the weekend and get appointments, then you will need to allow that.
Okay.
So I'm going to put in every weekend is allowed if Ms. Betters requests. Okay. Anything else that the parties need just temporarily before we're back?
I don't think
that
so.
works.
Oh,
Okay.
a phone number for Miss Day so that I can contact her.
And Miss Betters, that's for you as well.
Okay.
Thank you.
Okay. And then so I don't think we need anything else on this. I'll get that new order signed. I have a lot of people still online, but I think they are predominantly all here for this case. The only name I'm not recognizing is Corey York.
That's the other grandma.
Ah, okay. Thank you.
Is anyone
Okay,
present
so
on
I'm
Guardianship
going
of
to
Roman
recall
Recall
number
number 6?
Excuse me, Your Honor. Anything further on the Billet case?
No, sir. Thank you for asking. You are free to log
Okay.
out. See you back on the
All
night.
right. Thank you very much.
Ms. Betters, you're free to log out as well. Ms. York, Ms. Bullock, you're both free to log out as well.
Thank you so much.
You are welcome.
Okay.
So then on number 6, this is the parts were, oops, let me get back into my docket here. The proposed guardians were back in front of me on an emergency petition on November 7th. I declined to sign an immediate order out of concerns for criminal history of the proposed guardians. I allowed them additional time by way of a continuance to today at 10:30 if they wanted to seek counsel or file any new information about the court's concerns. Nothing has been filed. I don't see them present today. So I'm going to go ahead and strike the hearing. The net result of that is that the order denying their petition remains in place. Okay, we'll go. Am I missing any cases? I think that's it. Okay, I'll go ahead and end docket.